So Mike, I'll hand it over to you.
Awesome. All right. Krista, thank you so much. So thanks for having me, everybody. My name is Mike Monteforte. I am an estate planning and elder law attorney. My office is in Woburn, Mass. I love talking to people about this stuff, so I appreciate you taking a little time to listen to me, but feel free to ask questions as they come up. So if you've got yourself on mute on your computer, feel free to unmute yourself and ask the question. And then we'll keep some time at the end for anybody that's got additional questions. But if we're talking about a specific topic, and you've got a question about that topic, don't wait till the end. Just jump in. I'm happy to answer them on the fly. So again, one of my favorite things to do is talk to people about this stuff. My kids laugh at me about it because they think that what I do is boring. But to me, it's not. So just real quick about me. I've been an attorney for 20 years. I've had my own practice for 15 years. I have a staff of 5 people, including one other attorney that works at my firm. I do all of the strategic stuff for my firm. So all of the estate planning recommendations and that sort of thing is all strategized by me. I've specialized solely in estate planning and elder law for approximately the last 8 years. So real quick on just, kind of how I got into it, and then we'll kind of dive right into some of the subjects of what we're going to talk about. So it was probably 8 or 9 years ago. I had been on my own, had my own practice for around 10 years. I was doing some estate planning, some real estate, some business stuff, a little bit of everything. And at that point, my grandfather started to suffer from dementia. He had early signs, small things at first, but things that, kind of got worse and worse over time, to the point where he and my grandmother decided that they were going to sell their home and that they were going to move to an assisted living because my grandfather needed more care than what he could get at home, and more care than my grandmother could provide for him. And they had, worked their whole lives. My grandfather worked multiple jobs. He was a World War II veteran. They had a paid off house. They had some money in the bank, and they knew that they were going to have to, use their money to pay for their care in this assisted living facility. And I'm the only lawyer in my family. So, my mom and my aunts came to me and said, Mike, what do we do? Is there any way to help them protect the money that they've, worked and saved over their entire lives? Can we do anything? And at the time, my answer was, you know what? I have no idea. Because I said, I'm doing real estate work and business work, and I'm writing some wills, but I don't know anything, about this, not enough to be able to help them. So I said, okay, I need to learn how to do this because I need to help my grandparents in any way that I could. So I jumped in head first. I took every class. I read every book, every seminar, anything and everything that I could do to learn more about estate planning, elder planning, nursing home planning. That's what I did. And I was able to help them in many ways. The sad fact is that they really had waited too long to plan. A key part of doing this stuff is planning ahead and trying to set things up early. And so they really had missed the boat on that, especially by the time my grandfather got worse and ended up having to go into memory care. And my grandparents were paying for 2 different units at this assisted living. My grandmother was in assisted living. My grandfather was in memory care, and they burned through their money very, very quickly. And so, in learning everything that I could to help them and doing everything that I could for them, I realized that, there is a need for this. There were a lot of other people that were in the same place we were. Not knowing what to do, not knowing how to plan, not knowing what they were entitled to and what they weren't. I realized that I enjoyed the work, and that, if I could help other people avoid some of the problems that my grandparents went through, then I was doing a good thing. So from that point on, I cut all the other areas out of my practice. I solely do estate planning and elder law. Just keeping up on the rules and the changes and the way that this stuff fluctuates day to day is a full-time job in and of itself. So to be good at it, you really have to focus on it and pay attention, because these rules change day to day. So that's what I do. I've done nothing but that type of work for the last 7-8 years or so. I'm married. I have 2 kids. I've written 3 books on estate planning and elder law. If at the end, I'll provide you with an email address for anybody that wants to request the books. We give them out free to anybody that wants them. So we'll give you an email address at the end, where anybody that wants the books can reach out, and we'll send them out to you for free. I've got, I don't know if you can see them, but the first one I did is called Planning Ahead. It's an estate planning and elder law guide. This one is made up of the information that I wish I knew when my grandfather got sick. And it's written in plain English, no legalese in there. And then my second book is regarding people applying for long-term care through Mass Health and Medicaid. And we'll talk about that as well. So at the end, I'll give you an email address. Anybody that wants the books, there's no obligation, there's no cost. We give them out free to anybody that wants them. And I'll give you that email address at the end. If the information that I'm going to give you today is helpful to you, that's all that I'm looking for. Both of my grandparents have since passed on, and I look at it like, well, I do this work. Anybody I help by doing this work, I hope I'm making them proud, and that somehow they're able to see me and that they're proud of me. So anybody who wants the books, you just need to ask. We'll give you the email address at the end. I think what we'll do is we'll jump right into the basics, kind of the basics of what estate planning is and the kind of base documents that we use to start an estate plan for someone. Then from there, we'll go into a little bit more sophisticated stuff like trust, and we'll talk about long-term care, ways to pay for long-term care, coverage for long-term care, that sort of thing as well, okay? If anybody has specific questions about things like Medicare or veterans benefits, we can talk about that at the end, but I'm not going to get into too much detail on those topics as part of this seminar, but it's something we could certainly arrange time and speak about later. The other thing is, because I talk for a living and I talk all day, I'll say, excuse me, at this point, you'll have to see me take a few sips of my tea as we go, because my voice will start to go on me if we get too far. So I'll apologize for that in advance. You'll occasionally have to take a sip, and we'll dive kind of into estate planning basics now. So we'll start out with what my office calls the big 3. And those are the 3 documents that we use as the centerpiece for any estate plan, okay? And an estate plan is just a collection of documents. It typically includes a will and a few other things. Most of us know or are familiar with what a will is, what a last will and testament is, and what it does, but I'll touch on it real quick, and we'll go through the other documents that are part of our big 3. So all that last will and testament is a set of instructions. It says, if I pass away, here's what I would like to happen to my property. So I'm married, I have 2 kids. My will says if I pass away, everything's going to go to my wife. If something happens to her or she predeceases me, then the next plan is for everything to go to my kids. All right. So all that document is, it's a set of instructions. It names somebody to be in charge. That person that we name to be in charge, the term most people are familiar with is executor, okay? And that's someone that's job it is to follow the instructions in your will. Now, the Massachusetts rules changed back in 2012, and the powers that be decided we're not going to use the term executor anymore. We're going to change it, and we're going to call it personal representative. So any new documents that you get, you're not going to see the word executor in there. You're going to see personal representative, but it means the same thing. All right. I still typically say executor in my conversations because it's a term that everybody knows. All right. So we name somebody to be in charge. That's our executor. Their job is to follow the instructions in the will. And those instructions are put in writing so that our executor knows what to do and knows what to do with our property if we pass away. Okay? So much of the documents that we're going to talk about today really are very similar to a will in that they are lists of instructions. Here's what I want to see happen if I pass. Here's what I want to see happen if I get sick and I can't make my own decisions anymore. This is what I want to see, and this is who I want to be in charge. Okay? So that first document in that, what we call the big three, that's your last will and testament. All right? And then our other two documents that are part of that big three are what we call a power of attorney, and the other document is called a healthcare proxy. And some of you may be familiar with those and have an idea of what they are, and I'll just touch on them briefly so that everybody has an understanding of what we're talking about here. My last will and testament says what's going to happen if I'm dead, okay? But under Massachusetts law, your will has no legal significance whatsoever until you're dead. Okay, your will means nothing while you're alive. That's because we've all got the right to change our will as many times as we want for any reason that we want. And so, yeah, that's great. If I pass away, my executor's got these instructions of what to do with my property. But what if instead of passing away, I am incapacitated in some way? So I'm still alive, even if they're keeping me alive on respirators and feeding tubes and God knows what. As long as my heart's beating or machines are making it beat for me, no one can look to my will and figure out what my wishes are because technically I'm still alive, okay? That's where the other documents come in. A power of attorney and a healthcare proxy names somebody else to make decisions for me if I'm still alive, but I don't have the ability to make those decisions for myself. So that could be if I have a stroke, if I were in a coma, if I were in the middle of a surgery and decisions needed to be made, or if, like my grandfather, I was suffering from dementia and I just didn't have the legal ability anymore to make decisions for myself, whether it's financial decisions or healthcare decisions. I just don't have the ability to understand what I'm being told and to be able to make a decision, for my own care or my own finances. And in those cases, we're naming somebody else to step in and do that for us. Okay. So one of those documents being the power of attorney, that's the second document in our big three. This deals with financial stuff. Okay. So if I can't make decisions for myself, power of attorney allows me to name somebody that can step in, make decisions for me, even move money around if need be, acting in my best interest to make sure that financially everything from my bills are being paid to making sure that I'm applying for any benefits that I might be entitled to, and even moving money around to help me qualify for benefits. All right. So again, it's a list of instructions. I name somebody to be my power of attorney and step in and act on my behalf, but only if I can't take that action myself. All right. So even if I sign the power of attorney today, as long as I can make my own decisions, I'm in charge. But if we get to the point where I cannot, at that point, the power of attorney becomes active. Okay. And the individual that I've named can step in and act for me. The documents required and the provisions required as part of a power of attorney have changed a lot over the years. If you've got a power of attorney already, but it's an old document, if it's prior than or older than 2012, it's definitely something that you should take a look at and have an attorney take a look at, because the rules have changed a lot since then, especially when it comes to qualifying for things like Medicaid or Mass Health long-term care benefits. Power of attorney documents have to be written in a specific way to allow the person that you name to take action on your assets to help you qualify for benefits. And if those provisions aren't in there, clear, black and white in the documents, Medicaid and Mass Health can deny you for benefits based on their opinion that your power of attorney doesn't have the proper authority. So if your documents predate 2012, you should definitely take a look at them. Have an attorney take a look at them. It doesn't have to be me, but have somebody take a look at them and make sure that what's in there, what needs to be in there is there. Okay. So that's the second of our big three. So we've got the will as number one. We've got the power of attorney as number two. Number three in our big three is the healthcare proxy. And again, that's something that many of you may be familiar with. There are all different types and versions of healthcare proxy documents. And now we're not talking about finances anymore. We're talking about healthcare. If I can't make a healthcare decision for myself, that healthcare proxy document names someone else who can step in and make those decisions for me. Your healthcare proxy doesn't need to be the same person as your power of attorney, because we're talking about two different things. We're talking about money and finances, and then we're talking about healthcare. And the appropriate person for you to name to step in for you on those things might be two completely different people. Okay, so just as an example, my wife is my power of attorney and my healthcare proxy, but if she can't do it and someone else has to step in, right now my children are still minors. They're 17 and 16. They're not old enough to do it. So my cousin is my power of attorney. He's a smart guy. He's good with finances. He's good with money, but he's not my healthcare proxy. My healthcare proxy is my sister. She knows much better what it is that I would want healthcare wise, but she doesn't have the ability to deal with the money that my power of attorney would have to deal with. So I've got two separate people. That's okay. My daughter that's 17 has made it abundantly clear that as soon as she turns 18, she wants to be named as the healthcare proxy for my wife and I. And she's mature enough to do it. The law says you have to be 18. And, her reasoning was, Dad, I'm not looking to control the money, but I don't want anyone else making medical decisions for you and Mom other than me, because no one's going to know better than me, what you guys would want. But until she's old enough, it's my sister. Okay, so we've got this healthcare proxy document. They come in all different shapes and sizes. Sometimes when you go to the hospital, if you're having a procedure done, they'll ask you, hey, do you have a healthcare proxy? And if you don't, they'll give you a form. They'll say, okay, you can fill this out, and they'll keep it on file. That's okay. Those forms are okay to get you through a particular procedure or a surgery. If you don't have one, it's better than nothing. They definitely don't compare to a document that you would have an attorney draft up. Again, something's better than nothing. So if you don't have one and you're going to the hospital and they want to give you one, by all means, take it. But going forward, the documents that we provide or that other, estate and elder attorneys are going to provide are going to be substantially longer than a 1 or 2 page healthcare proxy that you might get from the hospital. The document that an attorney gives you is going to be designed to cover just a huge number of different circumstances, all right? It's very hard to be someone's healthcare proxy. We're talking about making healthcare decisions for somebody else, right? We're having to put ourselves in their shoes and try and get inside their heads and figure out what would they want. They're not in a position where they can tell me what they want. So I have to try and guess, not what I want, but what would they want? And there's guesswork there. What we try and do by having as detailed a document as possible is we try and get rid of that guesswork. We try and get rid of that gray area. We want your healthcare proxy to be able to look at that document and be able to find the answer to 99% of their questions, right? We don't want them to have to guess. We want them to be able to look at the document and say, okay, here it is. This and I'm comfortable making this decision because I have it here in black and white that this is what they would want. Okay, so Hospital forms, they're okay for short term, but not something that you should be using or relying on a long-term basis. Okay. The other pieces to a healthcare proxy that aren't typically included with, a hospital form or a few different things. One of which is a document that we refer to as a living will. It's a silly name because it's got nothing to do with a will at all. I wish they would call it something else, but it has to do with our preferences regarding being kept alive on machines if we're brain dead. All right. So if I have a stroke and they hook me up to all their computers and they're showing that, I don't have those, my brain is basically a flat line. I don't have those, up and down, recordings in my brain. And they determine that, I'm not coming back, that I am brain dead and that I'm not coming back, but that they could hook me up to a respirator and a feeding tube and keep me alive indefinitely. Do I want to be kept alive in that fashion, or would I prefer that, my wife and my kids let me go? All right. If my doctors agree, I'm not waking up. There's no chance that I'm ever waking up. It's a very, very difficult decision for any healthcare proxy to make, right? This is our pull the plug decision. And who the heck wants to be in charge of that? Because you get into, would they want this? Would they not want this? Should I do it? Shouldn't I? I don't know. I'm not sure. Well, that living will document is a clear way for you to express to your healthcare proxy your preferences, right? I don't want to be kept alive in that fashion. And then at that point, we're not asking the healthcare proxy to make any decision at all. All we're asking them to do is enforce the decisions that we've made for ourselves, right? And it's a lot easier to enforce someone else's decision when we know what it is than to have to be the one that makes that decision, all right? So what we're trying to do is take the guilt away from the person that we put in charge of this so that they know they're not really the ones having to decide anything. They're just enforcing the decision we made. And if any other family members want to question it, we have it in clear black and white. No, this is what he or she wanted. There's no ifs, ands, or buts about it. There's no room for argument or interpretation from anybody else. This is what they want, and I, as the healthcare proxy, am going to do, what they want. All right. So those couple of extra documents go along with the healthcare proxy. They're not something that would be included in a hospital form, but any good healthcare proxy that you get from an attorney that knows what they're doing are going to give you these pieces, and they're very important. So, when it comes to your healthcare, it's not something you want to take chances on. Even if you've got one of these hospital forms, look for something that's going to be a longer term solution for you as opposed to one of these 2-page documents. All right. So that's our big three: our will, our healthcare proxy, our power of attorney. From there, we'll dive into a little bit more sophisticated stuff and start talking about trust. But does anybody have any questions about the big three before we move on? If so, feel free to unmute yourself and ask. I'll give everybody a minute, and then if not, we'll move on and talk about trust.
Hi, I'm Em, and I have a question. Can you hear me?
Yes, I can hear you. Go right
thank
ahead.
you. Yes, thank you. What if you do not have an obvious person whom you would select to be either one of those roles? In other words, your executor or your healthcare proxy.
So
say you're an elder person alone and you have no family, or you're not from the area, you don't have close friends whom you would wish to impose upon for these weighty responsibilities.
Sure. And that definitely happens. Okay. So one of the things to remember is the distinction here between power of attorney, which is financial, and healthcare proxy, which is medical decisions. Okay. They have professional institutions that can be your power of attorney if you don't have anybody else. Now, if you have a trusted advisor, a lawyer, a financial advisor, even a CPA or an accountant that's familiar with your finances, you can ask them to be your power of attorney. The difference is when you hire a professional, it costs, okay, versus if you have a family member or a friend that you can name, you can typically name them, and you're not going to break the bank naming them, all right? But if you don't have anybody, you can hire a professional to be your power of attorney and to be your executor, or even be your trustee of a trust, and we'll get to that. Just know that they charge for that stuff, right? So if you hire a lawyer to do it, they're going to charge their hourly rate for the time that they spend acting as your power of attorney. But many people, they don't have another option. And so those professional options do exist. They just cost a little more. All right. It's a little different when we're talking about healthcare proxy. So lots of times clients ask me if I can be their power of attorney because they don't have anybody else. And I'm willing to do that in certain situations. But when we're talking about medical care, for most of these clients, I don't have, I may know everything about their finances, but not necessarily everything about their healthcare. The other thing is someone that's going to be your healthcare proxy needs to be able to answer the phone at 2 a.m. if you get rushed to the hospital. All right. So we tend to focus more on asking caregivers to be a healthcare proxy as opposed to someone like an attorney or a CPA. And you'd be surprised. People do form relationships with their caregivers, especially if you've got, in-home care, you've got somebody coming in on a pretty regular basis to help take care of you. The bonds that form between folks like that very often, reach the point where you'd be comfortable naming someone like that to be your healthcare proxy, and you'd be surprised at how often they're willing to do it, because again, they've gotten to know you through taking care of you, and people do form these relationships. So we don't have professional healthcare proxies that you can hire out, but you very often can select from your caregivers. With power of attorney, we can hire professionals to do that as well. Just be aware of the distinction between the two. Does that answer your question?
Thank you.
Okay, great. Any others about the big three before we move on and talk a little bit about trusts?
Big three. I have a question. Can you hear me okay?
Yep, I can hear you. Go ahead.
Okay, terrific. What about if you have a family member that is they have Alzheimer's, it's still early stage. When is the right time to develop a power of attorney around that? And what if it's a little too late? What if that person is already, how do you get their consent, obviously, if they're not coherent?
Understood. So let me talk about that a little bit. A lot of times when we've got early stage symptoms of dementia, Alzheimer's, we've got people that have good days and bad days. And what we have to judge, as being the attorney that drafts this stuff up, when they sign these documents, I have to notarize the document. And what I'm saying by notarizing it is that not only have I watched them sign, but in my opinion, they understand what they're signing. All right. And in the early stages of those terrible diseases, there are good days and bad days. And a lot of times at the beginning, there's more good days than bad. And then as the disease progresses, sometimes we see it's about even. And then eventually the bad days start to outnumber the good days. My advice is to do it as early on in the process as possible, because we're a lot more likely to have more good days left when they can sign this stuff. Okay. But even people that are a little bit further along into that disease, but are still having some good days and can understand on those good days what they're signing, we can do it then. So it's not too late at that point. There are times where I'll set up a time for a person to sign, and their family member will say to me, Mike, it's not a good day. It's not a good day today. Can we reschedule for another time? And then we'll do that, and I'll speak to the person, and it will be a good day, and they'll completely understand what they're doing, and we'll sign that day. But when we get to the point that there are no more good days, well, then what do we do? At that point, they don't have the legal ability to sign anymore, right? For them to really contemplate and understand what they're signing and be able to make the decision of putting someone else in charge. When we get to that point, if we've got no documents in place, that's when we have to look to the court. and we have to apply to the court for what's called a guardianship or a conservatorship, where we're asking the court to appoint someone to be in charge of the healthcare or the finances. And so basically it's a more expensive process. It's a more time-consuming process. You need medical evidence from their care providers to say that they can't make these decisions anymore, and we're asking the court to appoint somebody. So that's a last resort, but we definitely, it's got to be the last resort. We try everything before going there, all right? So if there's somebody that you're starting to see symptoms, or again, good days and bad days are starting to be around even, don't wait. Start the process, get the document signed while they still can. It's a lot easier, cheaper, and less time consuming than having to go to the court and ask the court to appoint someone as a guardian or a conservator. The court doesn't take that lightly. What we're asking the court to do is almost take away someone's most fundamental rights, okay? The ability to decide for themselves about their health care and about their finances. And so you really have to be able to prove to the court through medical evidence that this person isn't capable of making these decisions and asking the court to appoint someone else. So it can be done. That's our last resort if the ship has sailed on their ability to sign. But if there's a chance of someone still having the ability to, solve this whole problem by putting pen to paper, that's what we want to do. So don't wait on the process. You never know, even if someone's in early stages, sometimes early stages last for a long time and sometimes they turn on a dime. So just be aware of that. So I hope that answers your question.
Thank you very much. That was great.
Okay. Anything else on the big three documents before we move on? Happy to answer them if anybody else has any. Okay, so it sounds like we're good there. If other questions come up, along the way, just ask. I'm not going to tell you can't ask the question because we're done with big three. All right. So if you think of anything, just ask. So now let's talk a little bit about trusts. Okay. Trusts are one of the most misunderstood types of documents in estate planning. That's partially because there are so many different kinds. There are 100 different types of trusts for 100 different types of purposes. Lots of variation in what a trust is and what it does and why we're using it. And so part of what my job is when I meet with someone is to figure out, do they even need a trust? Because not everybody does, okay? I'm not someone that recommends a trust to everybody. Just because you walk in the door means you need a trust. No, that's not the case. What my job is to figure out what the client's goals are, and then how do I meet those goals? And if I meet some of those goals by using a trust, then I explain that and I explain why. So we'll talk about some of the more common trusts, what they're used for, and then we'll get into some of the more sophisticated trusts as well, just so that you have an idea. If we were going to sit down and talk about every single type of trust that exists, we'd be here for days. So I'll hit the high points with you. But part of what my job is, I'm asking, when someone hires me, they're hiring me for my expertise and they're relying on me to tell them, do you need a trust? Could you use one? And if so, what kind, right? So I sometimes make the comparison between, my plumber coming into my house to fix the pipes, right? I'm hiring that person and relying on their expertise to do a good job and do what they're supposed to do. I don't tell them how to fix the pipes because I don't know. Well, it's the same thing. People that haven't been trained on this for 20 years may have an idea of what a trust is, but don't always know, the differences. And so they're relying on me to tell them whether they need one and what kind. And that's part of my job. It's to figure out your goals and to achieve those goals through the estate plan we come up with. And sometimes that includes trust. So let me give you a couple of examples of some of the more simple trusts and why we might use them. Okay. So first type of trust that we sometimes recommend is called a family trust, all right? And there are distinctions between these different types of trusts. One of the major distinctions being Some of these trusts are revocable, meaning you can create one of these trusts and then later on decide that you change your mind and completely get rid of it. And some of these trusts are what we call irrevocable, meaning that once you do it, it's very, very difficult, if not impossible, to go back and get rid of it once you set it up, okay? And there are some times when a revocable trust is fine, and there are other times where a revocable trust is not sufficient for the goal that you're trying to achieve, and you need to do one of these irrevocable trusts, and we'll talk about that. But these early ones that we're going to talk about, these are going to be the revocable type, okay? So lots of families use what we call a revocable family trust, all right? And so what is a trust? It's a list of instructions, just like the other documents that we've talked about, all right? My will says, when I'm dead, do this with my property. It's a one-shot deal. I'm dead, my executor gives everything out, follows the list, and they're done, right? A trust is almost like a will, but we're talking about, instead of a short-term set of instructions, a one-time thing, we're talking about a longer-term set of instructions. We're talking about naming somebody. Now, we're not calling them the executor anymore because that's of your will. We're calling them the trustee. That's somebody that's in charge of your trust. And we're having them hold on to assets for a longer period of time. So that's kind of the distinction between a will and a trust. When I'm the executor, the will tells me give everything out. I give everything out and we call it a day. A trust is where I have to hang on to assets over time because those instructions tell me when to give the assets out, and it's not always all at once. So let me give you an example of that. Now, I use myself as an example in a lot of these situations. So as I said, I'm married. I have 2 kids. My daughter's 17. My son is 16. If I die, everything goes to my wife. But if something happens to her or something happens to us together, you know, we travel together, we're in a car accident together, whatever the case may be, and we're both gone, well, my children are too young to inherit all the money at their age, okay? So we set up a trust where we name someone else to be the trustee. In this case, it's my cousin, who will dole out the money to my kids over time until they're old enough to handle it, okay? As long as they're under 18, anybody under 18 needs a guardian, all right? Their guardian can be in charge of the money for their behalf while they're under 18, but as soon as they turn 18, if you don't have a trust and you just give them everything through the will, well, as soon as they turn 18, they're entitled to their share, okay? Immediately. And that's problematic for a lot of people. So I'll use my son as an example, okay? If I die, my wife's dead, we leave everything to my kids. Life insurance, a house, money in the bank, everything. And my son turns 18. And now he's got access to this money. He's going to go out and he's going to buy every sports car that you could possibly think of. He's going to buy every, Lamborghini and all this crazy stuff. He's going to buy, 4 sports cars at $250,000 each, and then he's going to have no money left, and he's going to be going to my daughter looking for money for college, okay? So, both my kids, they're smart kids, they're great students, but they don't have any experience dealing with, large sums of money. They're just, they're too young for that. So what my family trust says is that my cousin, who's the trustee, uses the money on their behalf in his discretion. Meaning he can say to my son, instead of a Lamborghini, why don't we go maybe look at a Ford or a Toyota and, do something like that and spend $20,000 instead of $250,000, okay? So that's what the trustee's job is, to manage the money would be my kids, and there would be called the beneficiaries of the trust, all right? The trust is designed for the benefit of certain individuals. Those individuals are called beneficiaries. My cousin doles out the money to my kids in his discretion, but the trust also provides that at certain benchmarks, they start getting some of the money to manage themselves. All right, and you can set that up at varying ages. For example, I could give them a third of it when they're, 21 or 23, another third of it when they're 25, and the rest when they're 30. All right, so you can pick any ages that you want. In the meantime, the trustee is looking out for them, using the money for their benefit. But even when they reach, say, 21, they're not getting everything all at once for them to manage. They're getting a piece of it, a percentage, 25%, a third, whatever the case may be, to kind of learn how to manage it and use it. And then, a few more years, they get some more, and a few more years, they get the rest. Okay. So that's a family trust. We typically recommend them when your beneficiaries are under 18. That might be your children. It might be your grandchildren. Or any other family members that are, that are minors, and that we know we don't want to leave them, a big chunk of money all at once. All right. That type of trust is revocable, meaning once I create it, I can change it anytime I want. As, for example, my kids get older, I might decide, well, they're doing pretty well for themselves. They're pretty good with money. I'm going to go back and amend my trust and change those ages to make it a little bit younger, because I think they'd be okay dealing with it at 23 as opposed to 25, whatever the case may be. Because this trust is revocable, I can make those changes anytime I want. All right. So that's a family trust. Another type of revocable trust we might recommend is called a Realty Trust. And that's where we might own a separate property, like a rental property or a vacation home. And we want to make sure that home doesn't go through the probate process. We want it to pass automatically to our beneficiaries if we die. We can set up a realty trust so that the beneficiaries we name inherit that property upon our passing. It allows us to name multiple beneficiaries, also allows us to name a trustee to be in charge of that property and set the parameters by which our beneficiaries can inherit. And that's a revocable trust as well, meaning we can go back and change it, we can cancel it, we can do whatever we want with it at any time. All right, so those are two of kind of the more, I don't want to say simple, but compared to some of the stuff we're going to talk about now, they're more simple trusts than these other types we're going to kind of get into that have a little bit of more specific goals that we're attaching to them, okay? For example, if any of you may have heard of something called either a special needs trust or a supplemental needs trust. Those are trusts that we set up for someone that has special needs or might be receiving government benefits, all right? Lots of government benefits can be what are called asset-based, meaning if the individual has too much money, they can lose their ability to qualify for benefits. So if I have a child or another family member with special needs and they're receiving some government benefits like a mass health or other benefits that they're entitled to, and then I die and I leave them my assets, and now they've inherited assets from me, they may very well have too much money to where these benefits that a lot of times are, you qualify for them by having low assets. Well, now all of a sudden you've got a bunch of assets because you've inherited, you can lose the ability to qualify for those benefits. The way around that is by setting up what we call either a special needs trust or a supplemental needs trust, where we're putting the money aside for this individual. We're not putting it in their name. We're not giving them full access to it. We're putting someone else in charge, right? That person called a trustee, to use the money for the benefit of the special needs person, but to use it in such a way that we don't disqualify them for benefits. All right. So that type of trust is a lot more technical because it's got to meet the requirements of the government. So it's a lot more technical than, say, a family trust or a realty trust. Another type, when we're getting into a little bit more sophisticated type of trust, I've got two more, and then we'll move on and talk about some other things. We oftentimes use trusts as a way to help with estate taxes. So Massachusetts has an estate tax. The Massachusetts threshold for estate taxes is $1 million. And most of us look at it and say, well, I don't have $1 million in the bank, so I'm not going to be subject to Massachusetts estate taxes. Well, Massachusetts, in their infinite wisdom, have figured out a way to look at your assets so that they don't just count money that you have in the bank to figure out whether you go over that $1 million limit. They look at the value of your house. They look at money that you have in the bank. They look at money that you have in retirement. And they look at your life insurance. So right now I have a life insurance policy, right? It's worthless while I'm alive. It only pays out when I'm dead. When I'm dead, my family gets this money. That money counts towards the Massachusetts estate tax limit. So because I'm married, I have a wife and 2 kids, I have a life insurance policy that's $1 million. Well, if I die, just by virtue of that policy, I'm already over the Massachusetts state tax limit, and my estate is going to be taxed by the Commonwealth of Mass. So they look at everything, even if it's something that you don't get the benefit of until you're dead, right? Be worth more dead than alive. They can tax you based on those values. So we use trusts. Sometimes they're called credit shelter trusts. Sometimes they're called estate tax trusts. We use trusts to help minimize the amount of assets that the Commonwealth of Mass can look at and include as part of your taxable estate. We can remove certain assets from your taxable estate by using trusts. We can remove life insurance. We can move the value of real estate, and we can even remove the value of certain other assets up to a point to help lower and in many cases eliminate your estate tax burden. The problem is many people don't realize that they could be subject to estate taxes, so they don't plan, they don't do anything about it. We've got a married couple. The first one passes away, leaves all the assets to their wife. Now, my wife has all the assets in her name. It's the house, the life insurance, it's everything. She passes away. What happens now is the money that's supposed to go to my kids is going to be taxed by the Commonwealth of Mass. And because I passed away and gave everything to my wife with no planning, they're looking at everything, life insurance, house, all of that. And my kids are going to be the ones that suffer. They're going to be the ones who, their share is reduced by what needs to be paid to the government. So this type of trust is a lot more sophisticated than some of the others we've talked about. This type of trust is still revocable during your lifetime. It becomes irrevocable when you pass, so that nobody else can change the terms of the trust after you pass away. And we're able to get the estate tax benefits from it. So that trust it's more of a technical type. For deeper discussion on that, there's a lot more about that in the books, and we have other written materials that we can provide if you've got questions about how to avoid estate taxes and estate tax trust. So that's one of the primary things that I do in looking at somebody's situation, is figuring out if there would be an estate tax burden and how do we reduce it, or how do we try and eliminate it altogether. If you go to an attorney that might write wills but isn't necessarily a specialist, a lot of times they have no idea what the estate tax limits are and how to go around them. So if that's a concern and you think your assets add up to over that threshold amount, it's something that you should look into and make sure it's somebody that knows what they're doing. All right. The last trust that we're going to talk about it's probably the most sophisticated of all the trusts that we write. And it's a trust that we refer to as a Medicaid trust. And those are trusts that we use to help protect assets, particularly your home, from long-term care. Okay, so that's a good segue into long-term care, and we'll move into our discussion about long-term care, how you pay for long-term care, and how trust can help with long-term care. But before I go there, anybody have any questions about the other types of trusts that we talked about? Not Medicaid trust, because we're going to get into that, but any questions about any of the others, family trusts, anything like that, I can answer.
Could I please ask what the approximate tax rate is for the estate tax?
So I'm going to give you a typical lawyer answer and tell you it depends. So what happens is the second you go over that $1 million, you're automatically taxed from the very first dollar. So in other words, they don't look at it and see, okay, you've got $1 million. We're not going to tax you on that, but we're going to tax you on everything over the $1 million. Nope, that's not how it works. As soon as you go over the $1 million, they go back and tax you from the first dollar, but it's a graduated scale. It can get as high as 37%, depending on how high over the $1 million you are. But it's a graduated scale where, the first 200,000 is taxed at this rate, and the rate goes up the more you're in there. So as soon as you have $1,001,001, they go back and tax you from dollar number one. So basically what we do when we're evaluating these things is we look at somebody's assets. We have a calculator that we use where we run everything through our calculation system, and it spits out a number for us that says, if you die with X amount of dollars, here's what the estate taxes would be. Just to give you kind of a rough estimate, if you die with $2 million, estate tax is close to $100,000 on $2 million in assets. It's $90,000 and change. But because it's on that graduated scale, I can't give you a set percent because there isn't one. It rises as the number of assets go up. Okay. Other questions about any of that I can answer. Go ahead.
A question. If you have a married couple who have no children and they have a irrevocable family trust.
Yeah.
I'm sorry, revocable family trust.
Okay.
And one dies and you settled that estate. And their estate was going to go to a particular charity.
Mm-hmm.
So the wife's alive and you're trying to write the next trust. What are the choices? Can you get rid of trust entirely? Does the fact that the husband and the wife in the beginning was going to, if something happened to both of them,
sure,
give their money to this one particular charity?
Yeah.
How can you change it? What happens?
So part of it is it depends on the terms of the trust, right? So the trust is this list of instructions, says what's going to happen. If it's a revocable trust and both of our individuals have the right to revoke it, we can change it even after the passing of the first person. Some trusts are written, though, so that they become irrevocable at the passing of the first person. So if there's an existing trust, part of what I do is I review and evaluate any existing trust to tell you kind of what your options are. Well, when one person passes away, this thing becomes irrevocable and we can't change it at that point. Or, well, when one person passes away, this thing stays revocable and we can look at whether it makes sense to even keep it or get rid of it. Maybe we don't need it at all, okay? And it depends on the nature of the gifts that we're leaving. Are we leaving charitable gifts to multiple charities? Are we leaving charitable gifts to one charity? Are we putting conditions on those gifts? Well, I want to leave this much money to this charity, but only if they do this, A, B, and C.
Simple.
Okay. So in those cases, it might make sense to get rid of the trust altogether and do those gifts through a will instead. Now, I'm speaking out of school a little bit because I haven't seen the document. So, for me to give you a kind of a real opinion, I'd have to look at the document. But speaking in general terms, you may not need the trust anymore after the passing of the first person. But it's a case by case basis. If it's revocable, it sounds like it might be a situation where we no longer need it. But it's something that I'd have to look at the document itself and the particular individual and their financial situation to be able to give you, a solid answer.
Thank you.
Right.
Two quick questions, please.
Yeah.
At the beginning of your discussion, you said not everybody needs a trust. So my first question is, what characterizes someone who does not need a trust? And the second is there a central repository someplace or a government office where you can place or list your documents so that someone would find them upon your death?
Sure. All right. So let me address both of those. Situations where someone doesn't need a trust. First of all, if somebody doesn't have a lot of assets, typical benchmark that we use is $25,000. Anybody that's got $25,000 or less in assets doesn't really need a trust, okay? Unless they've got a special needs individual that's their beneficiary, but otherwise, no, it's not really necessary. If we've got somebody that doesn't have a very, very high level of assets, and for example, all their kids are adults, and they're not looking to leave any money to any beneficiaries that are minors, right? So I'm married, but all my kids are grown. They're all in their 20s. I'm okay with them inheriting everything in a one-shot deal if I'm dead. We can do that through a will. They don't need a trust because we're not looking for anybody to hold on to the money for a set period of time. I'm dead. My executor gives it out, A, B, and C, and we're done. All right. You don't need a trust in that situation. If we're looking for someone to hold the money for a measure of time, in charge of it for someone else, or something like a special needs or estate taxes, then okay, we're going to recommend a trust. But in those other situations, and we're okay with it being a one-shot deal, we don't need a trust to accomplish those goals, okay? When it comes to, is there a central place where you can file a trust? So there's no government agency or government register where you can put this stuff. There are different services. So, for example, my office uses a service called DocuBank, and that's where we partner with a company almost like a central recording service. When we do estate planning for somebody, we upload their documents to this database that's run by DocuBank. Then what you have to do is you have to communicate to your trustees or your executors, your powers of attorney, hey, if anything happens to me, this is how you access my documents, all right? And so for people that use DocuBank, they get a little membership card, and it has the information on there about how they're able to log in electronically and get the documents. Because you can have the greatest estate plan in the world, but if no one knows that it exists, then it's not going to do you any good. So you do have to make sure you communicate to your power of attorney, to your executor, that you have documents, and this is how they find them. You don't have to share the documents with them ahead of time if you don't want to. You can if you want, but you have to make sure that they know how to find access, whether it's through one of these digital systems, or sometimes we hold the documents for a client. And you can say to them, hey, anything happens to me, call Monteforte's office. He's got the documents. You don't have to tell them anything more than that, but you have to tell them how to find this stuff. Because there isn't a place where we can all just go and search and see if you have a trust hanging out there, okay?
Thank you.
All right. So
Another question?
go ahead.
Another question? Many lawyers push estate trusts because they say you should avoid probate. You don't seem to think that that's an issue here.
Depends on the number of assets. All right. So, every case is different. I don't recommend the same estate plan for any two people. It's very customized to the individual person. There are times where we're trying to avoid probate, such as, with real estate. In real estate, if I own a home and I want that to pass, it's a lot easier to pass real estate through a trust than through a will. But if we've got lower amounts of assets, $100,000 or less, we may not need the trust at all just to pass down wealth of that size. I try to not complicate things that don't need to be complicated. So I will talk to each client about the difference. If we don't do a trust here and we have to run through the probate process, here's what it looks like, here's how long it takes. It's something that could be done pretty quickly because we're not talking about millions of dollars and maybe we don't need a trust. It certainly is quicker if we have one, but I don't ask someone to spend money on a trust unless they're really going to get a benefit out of it. So we discuss that. Part of what I do is I give the client options, all right? Here's some different options you could do. Here's the result of each of those options. And here's what I would recommend you do, but the choice is yours as to which one of these you choose. So you might not need a trust. We run everything through your will. It's going to take a little bit longer because it's going to go through probate, but it's going to be a lot cheaper for you to do an estate plan without a trust than to add one. And I let the client decide. So it's definitely not a situation where I always recommend trust, but it really does depend on the individual person, their assets, and their goals. Okay.
Thank you.
Right. So why don't we move on? We'll talk a little bit about long-term care. I know we're probably getting close to where we're at the end of our time. So let me hit long-term care and these Medicaid trusts, and then maybe we'll still have time for some questions at the end, okay? Lots of people ask me about long-term care. If I need to go into long-term care in a nursing home, or my spouse or another loved one needs to go to long-term care in a nursing home, well, how do we deal with that? There's 3 ways to pay for long-term care. You can pay out of pocket, meaning you use your own money to pay for the care. And at the cost of nursing homes, the average cost in Massachusetts is over $12,000 for a lot of the better per month. A lot of the better facilities, it's more than that. You can self-pay out of pocket, but you can burn through your money very, very quickly doing it that way. Second option is to pay through insurance. Some people have long-term care insurance. It's designed to pay for a stay in a nursing home. You pay for that policy while you're alive and while you're healthy, and then that policy kicks in if you have to go into long-term care. There are life insurance policies that include long-term care components. I'm a much bigger fan of those than I am of a straight long-term care insurance policy. Life insurance policies that have a long-term care benefit that say, well, if I die, the death benefit pays out. But if I'm alive and I need long-term care, I can take the death benefit early to pay for long-term care. Excuse me. So 2 ways to pay. Long-term care insurance, out of pocket. The other way is through Medicaid and Mass Health. You have to qualify for Medicaid and Mass Health by meeting their asset limits. They look at a single individual one way, they look at a married couple another way, and they determine if you qualify for benefits. If you have too many assets, you don't qualify, and you have to pay out of pocket until your assets get down to a level where you qualify. If you have a home that you live in, they can still qualify you for benefits, but they can place a lien against your home so that either when you pass away or the home is sold, they come back and collect against that lien for everything that they paid out on your behalf, plus interest, okay? So if you're trying to qualify for Medicaid through Mass Health, you have to position your assets in such a way that we remove those assets from the available pool that Mass Health is allowed to count, okay? And we do that by planning ahead. And one of the ways we do that is with these Medicaid trusts. So one of the most common questions I'm asked is, can I protect my home? If I need to go in a nursing home, can I do something to protect my home so that the nursing home can't put a lien against that house? The answer is yes. We can set up one of these Medicaid trusts. These trusts have to be irrevocable, all right? Medicaid doesn't acknowledge it if it's revocable. It's got to be an irrevocable trust. The property has to be in trust for 5 years in order to get the full protection, because Medicaid has this 5-year look back where they can look at any transfers that you made, including property that you put in trust. But if you put your home into one of these trusts, it's done properly, and the trust is written correctly, very, very technical, expert level trust here that we're talking about. Once the property's in trust for 5 years, if you apply for benefits at that point, Medicaid and Mass Health cannot count the house against you. They can't count it as an asset, and they can't put a lien against the house, all right? You've still got the right to control the house, live in the house, sell it, mortgage it, do whatever you want with it. So you're not giving up that kind of control by putting it into the trust. But putting it under this trust umbrella, once it's in there for 5 years, it's protected. That's why the key to this, a lot of this is planning ahead. So for example, with my grandparents, it was too late. They needed the care now. We didn't have that 5 years to spare. So putting the house in trust at that point wasn't going to help them. You need to do it early while everybody's healthy so that that 5 years can run. And after that 5 years, we've got the protection, all right? Now, if we've got a married couple, they do look at a married couple as a unit. An individual that's going into long-term care can't have more than $2,000 in their names. But if the individual is married and their spouse is not going to long-term care and the spouse is staying home, the spouse is allowed to keep some money. It's around $130,000 and change. But if you've got beyond that, you don't qualify, and they will tell you to spend all your money until you get down to the limits and then apply again. So there's pre-planning that we do, like these Medicaid trusts, to help protect the home, pull the home out of this pool of countable assets. There are other types of planning that we do that we call a game time decision. They're done when the individual needs care and someone's going into long-term care, and we move around assets at that time to help them qualify. So it's got to be this combination of both, not just one or the other. You've got to plan ahead and plan early, but there's still planning we can do at the end. But the key is to do both, not wait till the last minute, because when you wait till the last minute, you lose the ability to protect the home. Sometimes with a married couple, if one person's going in and the other person is staying home, we can still protect the house. But that second person, the person that's staying home, needs to be in their home for the 5 years in order to get that full protection. So again, the key is to start early. These Medicaid trusts are very technical, very sophisticated. They have to meet with all of the government's regulations. This is not something you go and have done by a lawyer that does some wills, but also does divorce and DUIs and some of these other things. It's got to be done by someone that this is what they do for a living and this is what they focus on. Because if you do it wrong, Medicaid or Mass Health won't count the house as being protected. They'll look at the trust and say this isn't correct, and they're going to count the asset or put a lien against it. I don't know how many times I review trusts for clients where they think they're protected, and they'll say, oh, I don't have to worry about it. My house is in trust. And I'll look at the trust and I'll say, no, I'm sorry. This doesn't meet the regulations. So sometimes they'll think the 5-year clock has already come and gone. Sometimes they think they're a few years into that 5-year clock, and I'll have to tell them, no, the 5-year clock didn't even start because this wasn't done the appropriate way. So be very careful with those trusts. Anybody that you're going to hire for those trusts, they can be amazing. They can protect your biggest asset, your house, but they have to be done right. Even if it's something you've done before, that you've done years ago, it's not something that you can just do and put away and put in the drawer, never to look at it again. It's important that you stay in touch with whoever drafted it for you, whoever your estate planning or elder law attorney is, and make sure that you're in contact because the rules change all the time. And if the trust doesn't change with it, you could render the whole thing to be moot, right? I know we're kind of getting towards the end of our time, so let me open it up to any other questions that anybody has. I promise there's a lot more information about Medicaid trusts in our books and available on our website as well. I'll give you the website and the email at the end. But what questions can I answer about long-term care, Medicaid trusts?
Are there additional assets besides houses that can be protected by these long-term care trusts?
So yes, absolutely. You can put cash into these trusts, but they're treated differently, okay? When you put real estate in, very little downside to putting in real estate. We put in real estate. If something happened and we wanted to take the real estate out, we can. We don't lose our rights of control. We don't lose the ability to live in the house, sell the house, do whatever we want with the house. Cash is a little different. We never put cash into one of these trusts if it's cash you need to live. If we know that we've got an amount of cash that we want to pass on to the next generation, look, I get enough money between Social Security and my pension and these other assets that I have in the bank, but I have this other $100,000 sitting over there. I know I'm not going to need it. I'm not going to need it to pay for my care. I don't want it to be counted by Mass Health. I want to turn it over to my family. You can put that cash into one of these Medicaid trusts. What we don't want to put in is any cash that you might need to live your life, because unlike real estate, with cash, once we put it in, we can't get it back out. Now, there's an emergency valve and a way to get it back out in an emergency situation, but we're basically breaking the trust and rendering anything in the trust available to Mass Health at that point. So we never want to put in cash that we think we might need. We're talking about excess cash that we want to pass on that we don't need for ourselves, okay? Other questions about that or long-term care, anything else?
I have a question.
Okay.
How do you stay up to date on updating your documents? How do you know when they need to be updated?
Sure. So part of that is up to the attorney that you hire. So we typically recommend people look at their documents at least once a year, right? Look at your documents, look at the names, look at who your beneficiaries are, who you've named as power of attorney, executor, that sort of thing. That's the kind of thing that you can look at for yourselves and make sure you haven't changed your mind or that the people that you named haven't passed away. If they have, that's the time to reach out to the attorney that did the drafting and update those items. But when it comes to changes in the law, well, now you're really relying on the drafting attorney to help you with that sort of thing. So most attorneys that do this for a living and practice solely in this field and know what they're doing offer programs where they say, okay, we're going to draft documents for you today, but we take the responsibility to notify you as part of this program when there are changes in the law, and we'll update your documents as the law changes. It's still always going to be on you to reach out if the names of the people that you put in you want to change. But when it comes to the law, attorneys that have these programs will reach out to you when the law changes. If you hire an attorney that doesn't have one of these programs, we recommend you at least do an annual call with your lawyer to say, hey, all right, I did this trust last year. Has anything changed? Is everything, with the law the same? Does anything need to be updated? But many lawyers put the onus on you. They give you the document and they say, okay, here you go. The rest is on you. It's up to you to call me if, you want to talk about changes. But some attorneys do have these programs where they will take that responsibility to reach out to you if there are changes in the law, but it's still a two-way street where you have to make sure you notify us if you want to change things like who your beneficiaries are, who your power of attorney is, okay? Does that answer your question?
Yes. Do you offer a program?
So my office does. There are a couple of different variations, but with the plan that we offer, we do a 15-minute call with our clients every other month. When it comes to things like Medicaid trusts, every other month seems like a lot, but that's how fast things can change in the Medicaid world. New cases come out every day and can change the way Medicaid or Mass Health interpret these trusts, meaning that something in those trusts might need to change. So we do a 15-minute call every other month. We say, hey, all right, the law is the same. What about in your life? Anything changed in your life? Well, this one got married, or now I had a grandchild. And okay, do we need to do some updating in your plan? We talk about it. If nothing has changed in the law or in your life, then the call is very short. Nothing's changed. Okay, great. I'll talk to you in 2 months. But that's how quick these things can change. Other questions? Okay, all right. So I don't hear any other questions right now. So let me give you a little bit of information. So if you're looking to find out more about this or a little bit more of information, there's lots of articles that I've written, reports, and things like that that are available on our website for free. The website is montefortelaw.com. So it's my last name, Montefortelaw, montefortelaw.com. All the books that I've written and the articles that I've written are available there for download for free. Or you can send us an email, and we'll be happy to send you either of the books or both of the books or any of the reports that we have. That email address is info, I-N-F-O, at montefortelaw.com. So info, I-N-F-O, at Monteforte, montefortelaw.com. If you're going to send an email, just put either in the subject line or the first sentence of the email that you attended this event. That way we make sure we know who's asking, because I want to make sure that you get everything and that you get everything at no charge. So just mention in there that you saw the seminar through through this event, through the Weston Council on Aging, and we'll make sure that we get everything out to you. Again, there's no cost, no obligation. Lots more information. There's videos on the websites too that talk about this stuff too. If anybody's looking for more information, we're happy to share it with you. Any other questions? Anything else I can answer? Right. It sounds like we're good. If that's it, then I can turn it over. Everything back over. I'll thank everybody for listening. I can turn it back over to Kristen. If anybody,
Thank you. Thank you very much. It was
Excellent,
wonderful.
Mike. Thank you so much.
no, it's my pleasure, you guys.
Thank you.
Very
So
good.
happy to
Thank
do
you.
it. Reach out.
Very, very helpful.
We're here if you need us. All right. We do lots of stuff online. You never have to set foot in the office if you don't want to. We do meetings by Zoom, signings by Zoom, so you never have to drive all the way here. Happy to provide you with any information that we can. Don't hesitate to ask, and we'll get it out to you.
Thank you
you.
very much.
Thank
Very
you.
clear, very helpful.
All right. Thanks so much. Have a good day, everyone.